introduce you at this point? And how are we for lights? Okay, well, you...
There we go.
All right, there we go. Okay, I think we'll go ahead and get started. First of all, I want to welcome you all here. My name is James Pierce, and I'm the president of a newly started up group here at the law school, the Student Organization for Legal Issues in the Middle East and North Africa. And as our name suggests, we're looking to get more programming at the law school that focuses on this region of the world, and from many different angles. And we've had an event, we screened the Battle of Algiers. Some of you may have been there, and this is excitingly our second event of the semester, and what we will hope to be a number of events throughout this year and in the future. Today, excuse me 1 minute, I left my notes behind. We're honored to have with us Professor Ebrahim Moosa. Professor Moosa is a professor at Duke. He is based primarily in the Religious Studies Department, a professor of Islamic Studies. He has a secondary appointment here at the law school as well, has taught courses in the past, and we hope will teach courses in the future. Do you know when?
Next year.
Next year. So next fall, look for his name on the schedule of courses. He has a tremendously diverse background. He was born in South Africa. He has a degree from Kanpur University in India, a postgraduate degree in journalism from London, an MA and a PhD from the University of Cape Town in South Africa, and he's also studied in India in a traditional madrasa doing Islamic studies. Until 1998, he was a professor at the University of Cape Town. From 1998 to 2001, he was a visiting professor at Stanford, and since 2001, he has been with us here at Duke. He wrote a book in 2006, Ghazali and the Poetics of Imagination. It was recognized by the American Academy of Religion as the best first book in the history of religions. This came out in 2006, and he's currently at work on two other books. You may have finished them subsequently, but a book called Islam After Empire, Text, Tradition, and Technology, and Between Right and Wrong, Debating Muslim Ethics. So we're tremendously honored to have him with us here today, and please join me in welcoming Professor Ebrahim Moosa.
Thank you, James, and thank you for all of you. Thanks to all of you for coming, and I know the pizza was an attraction, but I know my colleague James Scott Sillen, a neighbor, came for the talk, as many of you did. So thank you for this. I'm going to try and be as brief and schematic as possible in giving you some kind of overview of what Islamic law is all about. But I think more important is I think that you will have many questions, and I think that the way I will lay it out may, for some of you, be a repetition of something that you know, or for some of you, it'll be entirely new. So I will keep it as brief as possible. James has said, stick to something like 30 minutes, and then rest we will devote to some questions. So first of all, the big idea that you have in any discussion of Islamic law is the whole thing about Sharia. And as you see that, when the United States went into Iraq, and there was a hope that there was going to be a secular democracy in Iraq. The big surprise there was that people discovered there's somebody called Ayatollah Sistani, and Ayatollah Sistani has a lot of clout. And when they started writing the Iraqi constitution, there was a whole question that people in Iraq want Sharia, or the politicians in Iraq believed that Sharia is a very, very important dimension to any form of legislation in Iraq. So what is the Sharia? That is the million-dollar question. Because the word Sharia literally means something that is being revealed. So in many ways, Sharia means a revealed norms by revelation. But in order to fathom those norms, there's a whole process. There's a whole process and number of methodologies to divine the intention of the lawgiver, in this case, who is God. And so it is very much a process of engaging what exists in certain texts intellectually, engaging that intellectually, and then that understanding then constitutes what we think to be Sharia. Sharia is always also seen in Muslim history as the emblem of justice. This is a picture from some of the artwork and decoration at the Red Fort in Delhi, which is a Mughal palace. And there you see the scales of justice. I didn't do it much justice in my slide there, but in the middle there you'll see there are two scales, and that is the scales of justice. You also see there's I think there it comes up a little bit better. I'm new at this technology, so forgive me. And then you see that later in the Ottoman period, you see that the Topkapi Palace, etc., has the Tower of Justice, and there you'll see the Tower of Justice. So it's all, the Sharia is seen as emblematic of a notion of justice. If you look at ancient and early Muslim cities, these are Mamluk cities. It goes back to, say, around about the 16th century, etc. This is the city of Damascus there. There you'll see just the outline of the city, and then you see there the Dar al-Adl. The Dar al-Adl means the house of justice. Okay? So, and there you see next to it, etc., the Adrawiya Madrasa, which is the kind of the equivalent of a university. So university and law courts were very, very important. And guess what was taught in the madrasa? The main topic of study in a madrasa is, guess what? Anyone take a guess? Sharia law, exactly. That is the, if you go to a madrasa and you do not know Sharia law, then you should ask for your money back. And so that's the kind of Damascus, the citadel city. You see the same there. This is Aleppo in the Mamluk period, etc. There again you see the Dar al-Adl, and you see the kind of outline of the city. Another one here is Cairo. There you see that too, the Dar al-Adl of Al-Kamil, the mosque. So mosque, madrasa, and the law courts are very, very critical and central to Islamic culture and history. For many of you who know the early history of Islam, this is just kind of recap, that Muhammad, when he begins his ministry over a period of 23 years, etc., it's a mixture of what are the norms and values of this community, etc. And in early Islam, you do not have something what we today call Islamic law. It is basically a very kind of primitive or very kind of early forms of norms and rules and regulations that the community internalizes through their daily practice. Okay? It takes a couple of centuries that after Muhammad's successors, etc., come into, as they continue, you see for roundabout, say, the 9th century, you see the emergence of people now beginning to reflect as to how do we understand what this law is all about. And this understanding of the law also gets mixed up with questions of politics. One of the major issues that happens in early Muslim society is the whole debate around about, say, 70, 80 years after Muhammad's death. Major discussions erupt within the Muslim society, preceded by two civil wars as to who was most entitled to be Muhammad's successor. One viewpoint said that the succession would be decided by the community. So, and the people who decide by the community, they are known as the Sunnis. Others who believe that succession was designated by Muhammad himself, and that some people suppressed that information, and therefore the proper leaders did not come to power, and mainly Muhammad's son-in-law and cousin Ali, who was deprived of having the shot to power in the first instance, etc. And those people who were pro-Ali, known as the partisans of Ali, were known as a Shia. That's what Shia means, partisan, to be pro-Ali. So in the civil war, and that's how the major theological division in Islam happens between Sunni and Shia, and that theological rupture also impacts to some extent on the understanding of the norms and values of the community, which is known as Sharia, and there will be another term that we will use. So if anybody asks you, what is the big difference between Sunni and Shia, the quick answer to that is, it's all about succession after Muhammad. Okay. The Sunnis believe that the succession is decided by the community. Shias believe that the succession is by designation, and in Shiism you have different kind of different sects of subsects of Shiism. The most dominant one is what is known as 12 Shiism, the Ithna Ashari, who believe that there are 12 hereditary successors after Muhammad, and that the 12th one had disappeared and went into a great occultation and will herald the end of the world and will come back again as a messianic herald. There's also other forms of Shiism known as the Ismaili Shiism. The Ismailis are today represented by the Aga Khan. Anybody heard of the Aga Khan? Okay, some people have heard of the Aga Khan, etc. And the Aga Khan Foundation is a major philanthropic organization, and the Aga Khan lives somewhere outside of Paris. And then there's Zaydi Shiism that you find in parts of Yemen. So Sunnism is obviously the more dominant creed. But Sunnism is also internally varied, etc. I didn't want to go into those variations at this stage. Now, round about the 8th century and onwards, etc., you had a number of teachers, people who studied the teachings of the Prophet and the Quran and also studying the world and history at the time, began to develop principles of interpretation as to how do you understand the rules and regulations. So these master interpreters are known as mujtahids. M-U-J-T-A-H-I-D, mujtahid. There's a master interpreter. And there you have the kind of major, now there were many master interpreters, but over time, 4 or 5 of them, or 6 maybe, survived into becoming kind of canonical masters. And those are the first 4 that I have there for you: the Hanafi school, the Maliki school, Shafi school, and the Hanbali school, and then the Jafari school. Jafari school is the Shi'i school, etc., that most contemporary Shias follow. Now, the whole question is that the Malik, say Abu Hanifa was based in Kufa, which is today Iraq, and his school of law has a particular kind of flavor to it. They were very far from the main theater of Islam, which was where? Where was the main theater of Islam historically? Which part of the world? Anyone take a guess? What is today? Saudi Arabia, in Arabia, right? So Kufa is a little bit distant, etc. So in Kufa, Abu Hanifa was a major teacher, had a number of students, and over time his school gained credibility and acceptability, etc. But his school of law can be defined as a school that is very much based on reason and rationality, because they did not have too many traditions at that stage. Someone like Malik, who's based in Medina, in Arabia, Malik's school is basically a much more culturally located school. In other words, the culture and the practices of Arabia, and especially the city of Medina, for him is very definitive. So it's very much a school based on customary practices. And so the custom of Arabia is an emblematic hallmark of his law school. Malik had a student who was very smart. His name is Shafi. He has a longer name, but for abbreviation, we just call him Shafi. And Shafi basically said, I studied with you, and I'm happy with what I studied with you, but there are parts of it that are not acceptable to me. The fact that your school is so disorganized and so loose, and you do not have any kind of hierarchy of opinions, because I go to one part of Medina and people will say, this is the prophetic precedent. And I go to another part of the city of Medina and people will say, something completely opposite is a prophetic precedent. Now I need to figure out what is the real precedent. So Shafi becomes a major systematizer, and today people remember Shafi as the architect of designing the kind of foundations of Islamic jurisprudence. And Shafi then, after studying in Medina, moves to Iraq. He's also fairly itinerant, and as he moves around, his opinions of the world and about Islamic law also changes, etc. He finally ends, so in Iraq, when he goes into Iraq, he meets up with the disciples of Abu Hanifa, the Hanafi school, etc. And there he gets influenced by their thinking, etc., alters his views. Then he gets into Egypt, and in Egypt, he is now a major teacher out there. But in addition to that, Shafi also has, the Maliki school also spreads to Egypt there. So he encounters a different version of Malikism there. And there also he changes his views. So interestingly, in Shafi, you will find different gradations of his views and different kind of ways in which he alters his views because of the social context, etc. Ahmad bin Hanbal, the Hanbali school, so let me say something. The Hanafi school today is predominantly in places like the Indian subcontinent, parts of Egypt, parts of Syria, and so it's predominantly in that, in Central Asia. My gosh, how dare I forget that? So Central Asia is the Hanafi zone. The Maliki school is all of North Africa, mostly, most of North Africa. So Morocco, Tunisia, Algeria, parts of Egypt. You go down to Mauritania, on the African east coast, on the African west coast, down into the Sahara. So Maliki. And you might find some Malikis in Sudan and other parts of maybe that's about the zone there. And then the Shafi school, predominantly Southeast Asia. So Indonesia, Malaysia is a largely Shafi zone. And also parts of Egypt, parts of what is today the Fertile Crescent, in Lebanon, Syria, Jordan, those parts of the world, etc. Ahmad bin Hanbal, the Hanbali school, Ahmad bin Hanbal was a student of Shafi, is not really viewed by everybody to be a master jurist because he was largely a collector of prophetic traditions. But because of his expertise in collecting prophetic traditions, and prophetic traditions also is also one of the sources of interpretation of Islamic law, Ahmad bin Hanbal is known to be one of the founders of the Hanbali law school, and the Hanbali law school today is only predominant in Saudi Arabia. And the kind of identification or the hallmark of that law school is that it largely follows what the text says. People try to say it is literalist, but it's largely a kind of a textual tradition following the text, and we do not follow anything outside the text. So the text is binding, and oftentimes if the text conflicts, or if reason or maybe analogy says something, and the text, even though the authenticity of the text might be slightly dubious, etc., they would opt to follow the text rather than following legal and following analogy. So that's a kind of a thumbnail sketch of that school. The Ja'fari school, Ja'far bin Sadiq, one of the major imams of the Shiite school, he also lived in Iraq. In fact, Abu Hanifa, Nu'man bin Thabit is his proper name, but the Hanafi school, the first one, he studied with Ja'far bin Sadiq. He was a student of Ja'far. And so therefore you can see in the early period there were no kind of strong dividing lines between Sunni Shia. They used to study from each other. Later on these lines become much more crystallized. And Ja'far bin Sadiq school is very much a kind of a rationalist school, very strongly rational in its interpretive framework. When we move on from that, so what you see in the classical period, you will note that the key issue that all these master jurists did was to do ijtihad. Ijtihad means to engage, it literally means intellectual effort. In other words, and that is literally the meaning intellectual effort. More in terms of formally, it means that you have to lay out the principles of interpretation and do ab initio, from the very lay out the groundwork of interpretation. And once you are recognized to be a credible individual who lays out the groundwork of interpretation, and if your framework and your paradigm gets acknowledged by others and you get a lot of students, And that's the way you get, you develop your authority. And so those five figures that I mentioned to you on the previous slide, they are all considered to be absolute mujtahids. In other words, they do ijtihad. They are the master jurists. And in many ways, they become somewhat canonical figures, and their authority is oftentimes seen as beyond reproach. So there's a certain kind of sacralization of their authority, okay? And so it's very difficult to say that Abu Hanifa was wrong, okay? Because you're going to immediately get a lot of kind of pushback. But Shafi would say that Abu Hanifa is wrong. Malik would say that X is wrong. Amongst themselves, they can fight, okay? Or later on, you can show that your law school is better, but there's a certain kind of borderline that there's some kind of decorum that you must maintain in the way in which you offer critique, because they're also revered because not only of the intellectual genius, but also because of their piety. So in some ways, they have a kind of, there's no sainthood per se, but they have kind of a saintly halo around their personalities. Now, when these people and when these jurists, after they lay out the principles of interpretation, and when they begin to now apply their minds to it, etc., when they try to divine what the Sharia is saying, the end product of that is known as fiqh, understanding. And so when you study fiqh, people will say, okay, you're not studying understanding, you're studying Islamic law. Fiqh is the Arabic name for Islamic law. In other words, you're trying to understand what the moral values are. And therefore, also the term Islamic law is somewhat of a misnomer, because law in a modern context, people think of it in terms of what is enforced by the state authority, enforcement, the sanction of the state. And therefore, it's somewhat of a misnomer. The word Islamic law is identified in that way when colonial authorities came to Muslim lands and saying, okay, they have norms, rules, and regulations, and there's some kind of enforcement of it. They say this is Islamic law. But Islamic law is broader than that. There are aspects of Islamic law such as homicide, criminal penalties, etc., and also other kinds of offenses that do get punished by state authority. But there's a larger part of that is about self-surveillance, and the sanctions are not of this world, but of otherworldly sanctions, etc. So therefore, it is a kind of a combo, a hybrid of what I would call juro-moral ethics. Juro-moral ethics. In other words, there is a kind of a juristic framework. The methodology is very much juristic because of this highly organized methodology. It has a kind of juristic framework. And that people who undergo that kind of training also become judges, okay? But others also become counselors at another level, in other words, for communities, as they engage in educating people about how to develop the self, how to be good people. So they become moral counselors at another level. So Islamic law per se is not only about state enforcement, but also one that people study on a daily basis. So you will see that in the United States or any other part of the world, most Muslims would have some kind of manual at home called Islamic law that will deal with their daily rituals, okay, which is the 5 pillars of Islam, etc. But also other things, what do you do when you have to do your banking transactions? Can you take interest? Can you not take interest, etc. How do you deal with questions of marriage and divorce? Okay, there's the U.S. law, but what are the requirements of our religious values, etc. So all those kind of debates, and people will be continuously making those kinds of inquiries, etc. So as I said, bulk of the sanctions in Islamic law is based on your religious conscience. One of the things that I don't have on the slide is that when people want to know what the ruling is on X, okay, then they would write to an authority who specializes in Islamic law, and they'll make an inquiry. They send a question in writing or orally, etc. And that person will do some study and give you an answer. And that answer is known as a fatwa. That is what a fatwa is. A fatwa is an academic jurist doing some research and finding you the answer of a question that is in some ways unprecedented, but try to find for you the answer in the tradition. So that's a fatwa. But since the Ayatollah Khomeini said something about a writer called Salman Rushdie. Anybody know about that? Salman Rushdie. And Salman Rushdie wrote a novel in the 80s that's called Satanic Verses, and in which he lampooned some major figures of the Islamic tradition, etc. And that was seen as offensive by many Muslims. And when the Ayatollah came to hear about it, etc., he just quoted something out of a medieval textbook and said, well, anybody that blasphemes the Prophet, he should be killed. And ever since that time, etc., the fatwa is in most Westerners' minds, is seen as an edict, when it is not something like that. It's not an edict. But because the Ayatollah also had a major position within a state, he was the head of the state, he was the supreme authority of a state, etc., it transmitted in that way and was seen as a very kind of irresponsible statement of him to make, and obviously he never backed down on it, and that created major international imbroglio. Yes, sir?
I don't remember the facts of the fatwa that was issued by Rushdie. Did somebody actually write to the Ayatollah?
No, someone didn't write to the Ayatollah was watching television. Okay, he was watching TV, and people were dying on the streets of Bombay at that time, Mumbai today, because there were protests and police were firing, etc., and people were dying. So he asked, what's going on? And said, well, there's this writer who has written this book, and people are up in arms, and therefore there's all this conflict, etc. So what did he say? So someone told him what he said, etc. Now, it is true that in classical Islamic textbooks, etc., blaspheming the Prophet is seen as a capital offense. So he just recited that, and someone announced it, and then a major foundation, very zealous foundation in Iran, on top of it said, anybody who kills Salman Rushdie gets $1 million. And that just put the whole thing in a different perspective. In some ways, we're happy that didn't happen, that anybody didn't get a hold of it. And Salman Rushdie was under the protection of the British government for about a decade. Okay, so the sources of Islamic law is something that most of you know, is the Quran. Now, you must understand the Quran consists of about 6,000 verses. Not all the verses in the Quran, not all the verses on the Quran deal with law. There's only about 500 verses in the Quran that deal with what we call legal matters, do's and don'ts. The rest of it is all stories about ancient prophets, about, God's relationship with humans, etc. Okay, so only about 500 verses. So these 500 verses become the focus of juristic study. But there's a much more larger corpus of materials known as the Sunnah. And the Sunnah are the statements, the endorsements, and the practices of Muhammad that are then subject to a great deal of scrutiny. What are the correct Sunnah and what's the incorrect one? Because reports also grow over time, and people's memories are faulty, and transmitters are, it's a very complicated study, but these then become canonized in major books, in the Sunni and Shiite books of hadith, etc., that become the repository of juristic study and examination, etc. The other thing, third source, so these two are kind of the two primary sources. You look at the Quran and the Sunnah. Your secondary sources is, as a jurist, as a scholar, you would look at what consensus was arrived at by early Muslim communities, and especially intellectual communities, juristic communities, not so much what the lay people say, but what the intellectuals in the past have said. That is known as consensus in the Sunni tradition. And in the Shiite tradition, it's mainly, the difference is that the Shiites don't believe in the consensus of the community, because politically the consensus of the communities basically push the Shiites out of power, remember? Because the Shiites are not so much about consensus, but rather what is the right thing? And the right thing is somebody must say it. The Prophet said so, that Ali should have been, according to the Shiites, Ali was the proper successor. Similarly, for the Shiites, it's about the authority of the infallible Imams. The authority of the infallible Imams, those 12 Imams, that becomes an important source of reference. Then the difference between, on the fourth source, for the Sunnis, it's about analogy. In other words, a very limited form of use of reason. And for the Shiites, it's much more flexible, that any form of reason can become a source of inquiry, etc. Let me give you the difference example. Say for instance, the Quran has a prohibition on the use of alcohol, okay, wine. But now you have other kinds of substances that intoxicate. So Sunni jurists, and also Shiite jurists, but Shiite jurists use a different kind of modes of reasoning. In other words, analogically, because say, cannabis or any kind of substance also intoxicates, the ratio or the reason why alcohol was prohibited is because it intoxicates. Then that the rule that is known for alcohol, which is prohibition, gets extended by analogy to something else that has a common kind of ratio or reason of why the rule is in existence, etc. So that's how the Sunni tradition operates. And sometimes people try and extend the ratios. I call it like elastic bands. You try and extend it to all kinds of things, etc. And to get the whole order under control, to have control over the moral order in that way. There's been a lot of debate about this, whether qiyas, which is analogy, is allowable. There's a tremendous amount of debate, whether that doesn't generate kind of false law for some, etc. Some say that human beings do not have the authority to extend God's law, so just stick to what the law says explicitly. And if you want to prohibit on any other grounds, then use human authority, secular authority, to outlaw things. So, for instance, a 11th century jurist in Muslim Spain by the name of Ibn Hazm, for instance, Ibn Hazm said that God's law is only those things that are explicitly documented in the Quran and the authoritative Sunnah. And if you want to make other kinds of substances, if you want to prohibit that, etc., use human authority as the grounds, but don't use it in the name of God or in the name of the Prophet, etc. So there was a huge debate, and that debate continues till today. Now, each of these schools that we have talked about, these classical schools, have a hierarchy of jurists, etc. They are a hierarchy of texts, etc. And that is the way you do it. But over time, what has happened is that because the classical authorities were framed in this kind of halo of sacrality and authority, etc., and subsequently what it was all about is about following authority, doing taqleed, to follow the authority of the early jurists and people in that hierarchy. So there was a diminishing rate of ijtihad, an attrition of ijtihad. Or ijtihad, at least in the Sunni tradition, took a different name. In other words, it's about following authority. In the Shiite tradition, it's somewhat different. In the Shiite tradition, it is that every Shiite must follow a living master jurist. Every Shiite must follow a living master jurist. There's a joke between Sunnis and Shiites also. The Shiites always say, you Sunnis follow dead mujtahids, dead master jurists. We follow living master jurists, etc. So the thing is that this question of following early authority also resulted in a very kind of narrowing down of the dynamism of the law. In other words, newer experiences, newer developments, societal developments, were not often updated in a very creative and imaginative way because you are always locked into the paradigms of the early jurists. There were some major breakthroughs. So, for instance, in the 14th century, in Muslim Spain, a writer by the name of Al-Shatibi, Al-Shatibi, Shatibi tried to design a new kind of paradigm for Islamic law based on the objectives of the law, and the public interest of the law. And guess what? In the 19th and 20th century, everybody feeds off Al-Shatibi. But he did it in the 14th century, and he somewhat breaks the paradigm, and he becomes someone that people in modern times refer to. So the big issues that you will find that people will talk to you about and say, what we need in the modern times is we have to do new ijtihad. Now, ijtihad is a very controversial issue because there's a certain kind of programmatic qualification that you must have for ijtihad. You must know so many things, you must be accredited by your peers, etc. And so there's been a lot of debate about this issue. And in modern Islam, among Sunnism, there's been a division in the house on the question of ijtihad. And I'll come to that. Maybe I should talk about that straight away. What it is that the whole question of qualification, the debate is that can an individual become a master jurist in modern times? And so some people say, well, no one can encompass all the rules and can have all the knowledge in the way Abu Hanifa and Malik and Shafi had, etc. And others say, no, of course you can. Today we have computers and we can put all the hadith in a database, etc. and you can examine it, etc. But others say, no, you don't have that levels of piety and caution, etc. as the way the early generations had. So that debate falls out in that way. Others say, well, okay, if you don't have confidence in individuals, let's do ijtihad by committee. So ijtihad by committee. So you have the Islamic Academy, the Indian Academy of Islamic Law. You have at the level of the Organization of Islamic Conference, the OIC. which is a major umbrella group, transnational group of number of Muslim countries around the world. It's headquartered in Jeddah, in Saudi Arabia. They have the Academy of Islamic Jurists, etc. And you find a number of academies in the United States also. There's an Academy of Muslim Jurists that do work collectively. So there's a kind of, a return to ijtihad, but it remains controversial, and the flexibility, because there's no kind of universal consensus that let's just do it, from the get-go, and let's redesign the interpretive principles, etc. It is somewhat of a gray area, because people are not really designing new interpretive principles. They were using the old interpretive principles and working around it in order to create more flexibility within the law. Islamic law also changed over time during colonial times, etc. British, French came into parts of the Muslim world, etc., and supplanted the early, the Islamic law in terms of family law. The whole Sharia system was abolished, for instance, in India by starting with Hastings in Bengal, and replaced with modern codes of criminal law. But and also commercial law and other kinds of laws, etc. But the one area that they retained was Muslim family law. So Muslim family law, marriage, divorce, inheritance, and also endowments, Islamic religious endowments, those were preserved. But because they were preserved also in a new context of a nation state, many of these practices also undergo certain amount of change compared to the pre-colonial iterations, etc. Now, obviously, in post-colonial periods, etc., there's been a major demand for the application of Sharia law, etc. And people have been pushing in many parts of the world to have Sharia applied. The full gamut of Sharia must apply across the board. I think the best example of that you have is Iran. That Iran, after the 1979 revolution, insists that every aspect of Iranian life must follow follow Sharia rulings, from commercial law to criminal penalties to everything. And obviously that has caused a great deal of upheaval in terms of that the work was not done. So it's even in Iran, even though Iran and Shiites do believe in ijtihad continues, but the Shiites have not done better in terms of dealing with the new realities, have not done much better than the Sunnis in that scope, because ijtihad, when it's based on old interpretive principles and interpretive principles that do not take on board new social and political realities, etc., will lead to a certain amount of, not a certain amount, but a great deal of social upheaval. And so Iran since 79, and we're almost 30 years into the revolution, etc., is a society in which the law has undergone a great deal of change. And so if there's one part of the world that you can see Islamic law making adaptations, it is Iran. At the same time also, there's been major question marks whether some of in Iran, for instance, Sharia law is also seen as the sovereign symbol of Iran. Saudi Arabia also follows Islamic law to a great deal, but it also allows for a parallel system of, say, secular banks to come into Saudi Arabia. So there's not only interest-free banks in Saudi Arabia, but there's also other banks, etc. The Saudi political authority is a kind of a hybrid of a Islamically justified monarchy, but it also is trying to open up to other kinds of political experiences, etc., by having kind of municipal councils and some kind of elected authorities at the community level, but not at the higher levels. At the higher levels, the king has a kind of advisory council that advises him, but he's not bound by that advisory council. Pakistan sees itself as an Islamic state, but apart from originally having family law, and from 1980, for a brief period under General Zia-ul-Haq, where he wanted to Islamize everything in Pakistan, etc. After that, there was a whole reversal process in Pakistan, that people were not happy with the Islamization of the whole legal system in Pakistan. So Pakistan is somewhere in between. Sudan has the same kind of experience. Sudan, for some time, for a period of 10 years, went intensely into application of Sharia law at all levels, and then there's been a kind of a silent discontinuation of the whole process because it didn't always work. The most interesting part of this is that in the 19th and 20th century, I already touched upon that, is there's been a call to start ijtihad all over again, and there's been a great deal of discussion on that. And the major development has been that no longer do we have to follow the law schools of the past, but try and follow the best law rather than the best law schools. While that model has been acceptable in certain parts of the Middle East, etc., in Central Asia, Southeast Asia, amongst authorities, Muslim authorities, where this, you see, what is the difference is that in the Middle East, religion and the Sharia has in somewhat been regulated by the state. The state has taken over religion. So the state can impose from the top whatever kinds of policies it wants. So it can push this notion of ijtihad and following the best law rather than the best law school. In places like Southeast Asia, South Asia, Southeast Asia, and other parts, people are still very much sticking to the more orthodox law schools, etc. And they try to resolve their questions through the madhhab system, etc. And so there are different kinds of orthodoxies that you can see in different parts of the Muslim world. My critique of the whole discussion of ijtihad, I believe it's a kind of it's a non-discussion. If you are not going to take new knowledge on board, if you're not going to deal with the new social political realities and make that part of a moral juridical process, etc., ijtihad is very much like throwing stones in a Coke can and just rattling it all the time. It makes a lot of noise, but very little delivery. Or you can use any other kind of can you want to use, if it's a Coke can. So just to let you know that that Islamic law is not very, very far off the minds of some of the people working in Washington. So, for instance, on one of the freezes of at the U.S. Supreme Court, Islamic law was in the minds, as seen as one of the legal systems, etc. And there is Muhammad in the middle there with a sword in one hand and a book in the other. And a close-up to that is this one here, but it's not a great close-up either. I think I shall stop there and hopefully have some questions from you. Thank you. Yes, sir.
You mentioned with fatwa how it's been misunderstood by a lot of Westerners, how it's been discussed
right.
in this country. Are there other key elements of Islamic law that you think have been misunderstood in a similar way because the way they're discussed in the media or publicly?
Well, I mean, it's partly also the way in which I think the lack of care on the parts of many Muslims in parts of the Muslim world where these stories originate from also, and the lack of communicating effectively, that you have this kind of miscommunication. So it's not always a one-sided thing. Of course, I mean, in the way media reports about the Muslim world is often biased and slanted because of geopolitical interests, etc. So that is taken for granted. The question of, say, the question of gender, okay, women's rights, etc. The question of family law, etc. I mean, these debates, media will pick up one idea and say, well, in Iran, women do not have mobility, etc., which is not entirely true. Women in Iran possibly have more mobility than women in Pakistan or Saudi Arabia, okay? But there they have it in terms of that you must wear some kind of token covering of your hair, etc. And that has also been changing in a variety of ways. And there are intense debates. In Muslim communities throughout the world about the status of women. So there's a whole new kind of subjectivity and this debates about what is a woman's right and a woman's subjectivity and male subjectivity, the relationship between sexes. These debates are very powerful debates within Muslim communities, but the full complexity of it never gets relayed in a 20-second soundbite or in very limited newspaper space where there's there's not much time to discuss these kind of complexities. I mean, family law, for instance, in Egypt or in, say, Pakistan, etc., is constantly under review. You have better family law regimes, say, in places like Tunisia. In Tunisia, for instance, that was also done, take the example of Tunisia. Classical Islamic law thinks of marriage, the marital power being exclusively in male hands, patriarchal, classical Islamic law. Now, and there are very few grounds on which a woman can sue for divorce. Because from the get-go, the idea is not divorce, the idea is that the man can repudiate the wife. That's a classical, it was built in a patriarchal system, right? Now, over time, Muslim jurists, for instance, have given, early Muslim jurists, Ahmad bin Hanbal, that one that we quoted, developed very early on, saying that marriage is a practice. A woman can, at the very inception of the marriage, build in stipulations. That if you marry a second wife, this marriage is over. If you do not maintain me at this level, this marriage is over. You know, you can build in all kinds of stipulations because ideally marriage is a contract, okay? So in many ways, as societal changes took place, even in those very early years, the new realities were built in the minds of some jurists to create those kinds of possibilities for women to opt out of a marriage, etc. There's also notions such as that the man holds the power exclusively in his hand. He should ideally delegate it to a third party to exercise the termination of the marriage on their behalf, etc. So some of those developments have been taking place, and this discussion of the man having exclusive powers and can also informally the husband can repudiate his wife. That was seen in the 1960s years in Tunisia to be unacceptable to modern life. So Bourguiba, the president, with the religious authorities out there, then decided that the power of dissolution of a marriage will be taken exclusively in the hands of the state. The state will adjudicate through the courts when a marriage is no longer sustainable, when the parties petition the courts, etc. That is one of the few. And the other example of that was Somalia, believe it or not, which is a non-state today. And Somalia had one of the most progressive family law regimes during the time of Siad Barre. But Bourguiba and Barre both were kind of autocrats. So many of these laws are done through elites and imposed from the top with very little legitimacy on the ground, number one. Number two, very little debate in persuading Muslims in the narrative of Islamic law that these kind of changes are wholesome and possible. So with the result that these legal reforms, because of the lack of legitimacy on the part of the state, do not carry a great deal of authority on the ground. And that is the case in many, many places. I mean, Iran, I think the Ayatollahs lost a major opportunity to create a really dynamic situation because of their kind of authoritarian regime. There are aspects of Islamic law that has really, in Iran, updated itself in many ways. And there are many other aspects itself where it remained in a kind of a very classical pre-modern framework, etc. And it's also all about power. Mm-hmm. Yeah.
You mentioned that there is sort of a modern interest, relatively modern, I guess, interest in separating the law from the schools. How do jurists, when they're attempting to make that distinction, how do they go about actually dissociating the law itself from the schools? Because it seems to me from the presentation that you were so deeply inclined.
The thing is that when you say, let's give you an example. In the Maliki school, and in the Hanafi school, or in the Sunni schools rather, you need to have two witnesses at the time of marriage, right? In the Shia schools, you don't need witnesses at the time of marriage. You need witnesses at the time of divorce. Because if you're married, you just announce and everybody knows about it. I mean, the major thing is that you must announce a marriage. Now, arriving at those conclusions means that you have looked at the text in a particular way, you have certain kind of interpretive frameworks, you have ruled out certain versions, certain hadith, you have endorsed others, etc. Now, if I just take the end product of one school and the end product of another school, etc., I will have a kind of a mishmash, okay? I'll have a cocktail of end products, but the reasonings will be very complex. And so if you're a purist, you would worry that there will be a clash of reasonings at some point when you have these end results, etc. So that is one of the difficulties, is that you really ideally need a whole new interpretive framework that will legitimate new realities, because these realities have also come down through different kinds of social experience over time in different parts of the Muslim world, okay? So that is one of the difficulties, etc., how they can do it. But they are doing it because the major thing is to find some kind of legitimacy within the classical authority. Because of the tension between modern educated folk and traditionally educated folk, etc., who have different senses of what authority is. For the traditionally educated folk and the ulama, that is the religious leaders and the traditional jurists, etc., it's all about the authority of the text and the text of the classical jurists. For the modernists, it's all about the social reality that has to direct the meaning of the text. So that is the whole, for the traditional jurists, the text is constitutive of authority. For the modernists, etc., the text is directive. It directs you, but it's not constitutive, it's not conclusive, etc. You have to also engage it with social reality. Now, you will find some traditional jurists that are flexible in some areas. So, for instance, when it comes to, say, for instance, in Qatar, a major authority there based in Qatar is a man called Sheikh Yusuf al-Qaradawi. Qaradawi is fairly controversial because he has particular viewpoints on suicide bombing in Palestine, but he's against suicide bombing on 9/11 and other kinds of stuff, etc. Okay, so there's a kind of a conflicting authority, but he's a very, very influential scholar. But for instance, he in a place like Qatar is advocating that the homicide laws and the compensation for killing a man or a woman, etc., must now be equal, because in classical Islamic law, the compensation for a man who was killed, etc., the compensation in that case, in terms of blood money, is more than that of a woman. So he's advocating equality and parity there. For instance, on the whole question of, can a Muslim woman be married to a non-Muslim man? Okay, now that most jurists don't allow it. They allow a Muslim man to marry a non-Muslim woman, Jewish and Christian in particular. But Qaradawi and a whole group of jurists they have the European Council of Fatwa and Research, ECFR. They've got a major website. All the stuff is on there. The European Council of Fatwa and Research, for instance, have ruled that if a woman converts to Islam and she has a perfectly good marriage going on, and the husband, and the conversion has not created a conflict in their marriage, then there's no reason to end that marriage. Classical Islamic law requires, on conversion, if a Muslim woman, if a person converts to Islam, the woman in particular, marriage is over. So on these areas, they have done kind of new ijtihad, but it's extremely controversial. There are fatwas of heresy against Qaradawi for overturning the consensus of hundreds of years. Okay? So it is the whole question of that. Now, Qaradawi is a fairly traditional jurist, allowing for, traditional, but on the liberal side of traditionalism, etc. You're going to find others who are traditional and very conservative, refusing to make any changes there. Yes, sir.
What is the validity of fatwas around, for example, if the fatwa by Ayatollah Khomeini, like what validity does it have outside Iran? Or who is entitled to give a fatwa?
Good question. I always make a joke. I say fatwas are like elbows. Everybody has one. Everybody can give one. The thing is that the fatwas are given by anybody who is qualified, and the standards of qualification vary. Osama bin Laden thinks he can give a fatwa. Okay, he's never been for any kind of formal training, but he does believe that he had some training by some people, and he read some books, etc. And so he issues this fatwa, right, that you can attack the United States and its citizens wherever you can go. But he would not be regarded as an authority. But what has happened because of the change in modern authority and the Protestantization of Islam, in other words, knowledge being much more accessible, the ulama, the religious leadership, not only having authority, so many people who have not undergone training to become experts in Islamic law, many people, autodidacts, have now also become and have a lot of authority. So they write, they publish, and they know how to publish, and they know how to write for modern audiences, etc. So they have a lot of cachet with many communities. So, and also another movement has developed. There have been major movements like the rise of the Muslim Brotherhood in Egypt, the Jamaat-e-Islami in Pakistan. These are social movements with a religious flavor, and the people who write in those organizations, etc., while they do not call their writings to be fatwa, they are very authoritative for their followers. Now, who gives a fatwa? Ordinarily, it would be a person who qualifies to give a fatwa is called a mufti, M-U-F-T-I, a mufti. There are accredited muftis by nation states, etc. And in most nation states, there are also unofficial muftis, etc., people who are academic jurists, etc. So a mufti is a highly qualified academic jurist, and who knows how to deal with the sources and do interpretation. And yeah, so that is in the Sunni context. In the Shiite context, it's quite different, because as I told you, every Shiite follower must have a reference of authority, must have an ayatollah under whose guidance he or she lives. So, first of all, fatwas are transnational. So someone in Egypt would feel free to give someone in Europe or North America a fatwa, even though that person has no real direct experience what it is to live in the United States. And there's been a lot of discussion about that should a mufti give fatwas in context that he or she has no direct experience of that society, and could that not be erroneous, okay? Because it requires a lot of local knowledge too. But in the Shiite tradition, because there are no major authorities living in the United States for the Shiite, there are no ayatollahs living in the United States, many Shiites follow the authority of ayatollahs in Iran and in Iraq. So for instance, Ayatollah Sistani has a major base of following in North America and in Europe. And that is because his teacher, Ayatollah Khouei, had a huge number of authorities in North America, so he inherited those followers. The interesting case, for instance, the difference is Ayatollah Khouei, for instance, used to say that if a Muslim couple of Shiite conviction got a divorce in an American or Canadian court, that divorce is decisive and conclusive, right? So it accepts the secular system. Ayatollah Sistani today does not accept that. He wants the parties to go through the formal Islamic formula of divorce, etc. So you can go in, but that creates dualism, okay? And then there's also a lot of abuse, because the husband would say, no, we only divorced according to secular law, but we're still married according to Islamic law. And if he doesn't give her the talaq, the repudiation, then she cannot marry someone else. So it creates abuse, but Sistani is unmoved by that, etc. What Sistani has done, for instance, in that case, he said, well, those of you who want to follow Ayatollah Khouei's position, you can do so. But if the husband is from Ayatollah Khouei and the wife, well, in that case it will work. But if the husband says, no, I follow Sistani, and the wife says, no, you should follow Khouei, what are you going to do, you see? I mean, just an interesting case, 2 years ago, a number of people in Ohio somewhere, not because Ohio is in the news these days, but for other reasons, a number of Somalians working in a factory. And so, there's 5 times daily prayers, and there are 2 prayers during the day and 2 prayers in the evening, etc. So these Somalian workers wanted to go and pray, but every time they go and pray, it's 15, 20 minutes out of time. They want a special room and washing and ablutions, etc. So the factory manager, etc., then figured out, this is taking a lot, I lose half an hour, 45 minutes of their time, and the production doesn't work much that well. So he went to go and find some authority, and went to go and speak to this authority. And the authority said, well, under these circumstances, I would recommend to these folks that they should combine their prayers. In other words, the midday prayer and the late afternoon prayer, combine it in one time zone, okay? Now, in the Shiite tradition, that is perfectly acceptable, but not among the Sunnis. You can only do that when you are traveling. So when the factory owner came and shared this with his workers, etc., they were up in arms. They said, who's this guy? We want to find this mufti who gave this fatwa, etc. So he didn't, of course, he didn't share with them then who this person was, but they were up in arms. They were not convinced. A couple of months later, the imam, that is the prayer leader of the holy mosque from Mecca, visits, and these guys ask for an audience with this imam from Arabia. And so he has his audience, and he says, this person here in the US has given this kind of ruling that we can combine our prayers. So he was smart. He said, listen, I'm not from here. I don't understand your context, etc. So therefore, I cannot say anything. No, they said, you coming from the holiest of mosques, you're the most learned person, you must say something about it. So finally he said, listen, I agree with that viewpoint. So they said, you also went down that route? You also lacking? So obviously they were quite in disbelief that the rules can be changed by new social contexts, etc., and that's kind of flexibility. So oftentimes followers have much more stronger views than scholars, etc., on some of the issues because of a lack of understanding, or because the followers have a particular understanding of what the world should look like, and others, think differently. One more last question.
Well, I think we're
out of time.
actually out of time.
We can talk afterwards.
But yeah, let's again thank